for rebuttal today?
Yes, Your Honor, I'd like to reserve 5 minutes, please.
All right, and I will keep your time and let you know. We're getting a little bit early of a start, so I will keep my eye on the clock.
Good morning, Your Honors, and may it please the Court. Good morning, Mr. Donovan. Sarah Nelson here on behalf of the appellant, Mr. Christian Brown. This case presents the Court with the opportunity to answer 2 important questions regarding the definition and application of the term putative parent or putative father under the family or household member element in the domestic violence statute. The domestic violence claim in this case involves an unmarried couple with no children at the time of the incident, and the state argues that the parties were family or household members as contemplated under 2919.25 F1B. That subsection states that a family or household member is somebody who is the natural parent of any child of whom the offender is the other natural parent or putative other natural parent. So the 2 questions presented in this case challenge the putative natural parent language and ask whether it's appropriate to draw from Ohio's adoption statute and the definition of putative father found under that statute, applying that definition in a criminal context. And second, whether we can even apply subsection F1B, putative father subsection, to cases where no child is born.
Aren't you also arguing whether household member was established?
Correct. We are arguing that there was insufficient evidence of the family household member element in this case.
Okay.
Yes.
I'm sorry. You didn't hit yet. Go ahead, finish your answer.
No, the answer is yes. I mean, we are challenging. We've raised 4 assignment of error. The first is attacking the jury instructions. The second addresses statutory interpretation claim, and the third is the sufficiency issue. We've also argued a manifest weight claim, but I intend to focus on 1 through 3 in this argument, unless the court has any.
So what you're saying is, had the prosecuting witness in this case born a child from Mr. Brown, that he would be guilty of domestic violence. You say the child has to be born, but since it was in utero, it doesn't count as putative father.
Yes.
Okay.
Can you address, before you get into the merits of it, the state's argument that you waived that argument by not raising it at the trial court level?
Yes, Your Honor.
When I say that issue, I mean the issue of child and whether the child has to be born.
Correct. I think it's pretty clear from defense counsel's arguments in the context of whether the putative father definition from the Ohio's adoption statute should be applied in this case. Defense counsel makes repeated arguments going through the definitions in that section that it contemplates clearly that a child is born. She makes the argument there's 4 elements, and in each one there's some indication that there's a child already in existence for the father to take action.
Was there a Rule 29 motion?
Yes, there was. The Rule 29 specifically attacked the family household member element, but there was also an argument before the trial court in this case about using putative father in this case, whether or not it applied. And we think that there's 2 harms here. 1, was it appropriate to use that definition in the jury instructions? And 2, is it even applicable to the facts of this case? So yes, we think the issue was squarely preserved. It was before the trial court. The trial court contemplated the use of putative father in this case.
Was the argument of punitive father argued at closing?
From defense counsel?
That's correct.
If I can address on rebuttal to double check, I think the arguments were really specific to the family household member element. I'm just drawing a blank on closing argument.
It's okay.
So to get into the second assignment of error and the definition of child, there's no case law in Ohio that I'm aware of that actually delves into this specific issue. Yeah, it's come up in a couple of times in the sufficiency context, but no court has ever actually delved into the definitions of what is a natural parent of any child to trigger the putative father language in F1B. The domestic violence statute itself has 2 different terms, child and a woman's unborn. So we know these 2 concepts mean 2 different things because the legislature wouldn't use 2 different things to say what they mean to say the same thing, right? And then also in the adoption statute, child is also specifically defined as son or daughter, whether by birth or adoption. So within the adoption statute itself, if we're going to draw the putative father definition from it, we have to interpret that statute within its own definition scheme. And the adoption statute makes clear that there should be a child that is born in order for it to apply.
Would you agree that if, I mean, I think you would, if the child had been born, even, a day old, we wouldn't be having this argument. And I think in common parlance, people think of domestic violence as being a couple who are having or have had a child. So your argument would exclude anyone who is pregnant from domestic violence and make it a simple assault.
Not exclude in every case under the facts of this case.
Right, there may be a case where they're living together where they would meet another element.
Exactly.
But two people who are expecting a child together, generally that wouldn't be enough to fall under the domestic violence statute.
Not under F1B, they would have to meet the persons living as a spouse if they were unmarried. I think
Or if
that
they
would
had
be more
another
appropriate.
child together
Correct.
or.
Exactly.
All right.
And some of the cases actually have that type of factual scenario. They have some other, perhaps it's a woman has a child that the father has taken steps to kind of act as a putative father to that child, even though they are now expecting one themselves. In that sort of scenario, there's more of a family unit element that we don't have in this case. We have an on-again, off-again relationship with a couple who there's allegations of cheating. We don't even really know definitively if Mr. Brown was in fact the father of this child, even though that's what the state wanted the jury to believe. We have some questions in that regard. But again, under the facts of this case, I think the most appropriate analysis that should have been given to the question of putative father is that it doesn't apply because there is no child in this case. Just to circle back, I guess, to why I think it was problematic to even advise the jury of the putative father definition from the adoption code section. It's a pretty far-reaching definition in terms of who it could possibly apply to, which makes sense in the context of adoption because you want any person who possibly had a relationship with this woman to come forward to assert their rights, especially if they want the option to intervene in a potential adoption in the future. That concept is pretty inconsistent with what we require in the criminal realm, which is conviction beyond a reasonable doubt. The state has filed a complaint against this person and tries to prove to the jury beyond reasonable doubt that he is the one who had committed the harms against this woman.
Did the defense trial counsel argue against the instruction of punitive father?
Yes.
The jury instruction?
Yes, she did. And it comes in the same vein as when she goes through all the elements, putative father doesn't apply because the statute contemplates the term child, a child that is born. So it's kind of twofold, the first assignment of error and the second assignment of error and how they come out in defense counsel's arguments. I mean, she's really attacking the use of this definition at the jury instruction stage of conversation with the trial court. And I think that dovetails into two questions for this court. Was the instruction appropriate? And can we even apply it to this case with respect to how we define child?
But we don't even get there if we accept your argument that the child has to be born to be a child.
Correct. This court would not have to address the first assignment of error if it agrees that when we interpret the statute, it requires that the child be born and even to apply. And if this court agrees that that's how we should interpret the statute, then I would say that it also should reverse and discharge because there was insufficient evidence on the family household member element. There was no child born for the putative father definition to apply in this case, and there was no other evidence elicited on the F1A subsection. There's three parts, but the one that would most feasibly apply here would be persons living as spouse. And there was no evidence on that issue, no evidence of cohabitation to support that element.
You have about 2 minutes left if you want to reserve 5.
Yeah, if the court has no additional questions, I'll reserve the remainder of my time for rebuttal.
All right, thank you.
you.
Mr. Donovan?
Good morning, Your Honor. Ms. Nelson. I guess I'll pick up with, what could be the entry proposition, which is that this issue was not raised below. The discussion about the putative father and whether or not the child qualifies was post-Rule 29. It was in discussions about whether or not that definition, the one that is referenced by the OJI and the one that the court ultimately used.
So
The
there was,
discussion
you do agree that there was a Rule 29.
Yes, ma'am.
So why is that not enough?
The Rule 29 was specific to family or household member. It did not reference this issue. It did not attack whether or not a pregnant woman, whether or not a fetus qualifies as a child under the statute. As the case law is clear, if the issue is not, if there's a specific issue raised in the Rule 29, those issues that are not raised in that are waived on appeal. Therefore, we are saying that because that issue was not addressed during the Rule 29, it has subsequently been waived and cannot be raised for the first time here. The court was never given an opportunity to litigate that issue.
Was the determination of the punitive father instruction, wasn't that post Rule 29?
In terms of whether or not that would be the instruction that was given, Your Honor, is that? Yes, ultimately, the ultimate discussion was at the close of both cases after both Rule 29s had been addressed and denied. Then there's the discussion about a continuation of the discussion about what definition of putative father should be included in the instructions. Yes, that is correct. However, that's still not litigating it. That's.
Let me interrupt you there, though. I'm going to ask kind of a two-part question following up on Judge Zayas's. There wouldn't be anything to be litigated because she was pregnant and the child wasn't born. So there's no factual question. It's purely a legal question of whether an unborn child qualifies under the statute, just for that narrow purpose, as a child. And if, this is the second part, I guess I want you to address that, but the second part is, if we don't accept the argument that it was waived, I noticed that you didn't address that issue on the merits in your brief. Do you concede that the statute doesn't cover an unborn child?
Going in reverse order, I actually did cite case law in which other cases, I believe, I can't remember the district, and there was one of the federal courts that says, obviously, they qualify as a putative father because she was pregnant at the time. And while
Well, that deals with his status. I mean, he is potentially the father of that, or arguably the child's father. But what about the child portion?
Well, Your Honor, I'm a little bit confused there because if the other courts and the decisions that I'm citing say that obviously he's a putative father because there's an allegation that he was, he is the father of this unborn child in those cases, and that there's no argument as to family or household member in those cases. In order for him to be a father, it has to the fetus has to qualify as a child in order for him to be the father of that child. So I think the cases that I'm referencing, while I might not have specifically said this case stands for the proposition that a fetus qualifies as a child under this statute, his status as a father can only be if. So I think that we have addressed that a little bit in there. But to go back to the first part of your question, when you said that the litigation, when I'm referencing litigation, that legal issue was never put before the court. Therefore, the state wasn't given an opportunity to present it to the court. The court has never made a determination on that specific issue because it was not presented with that question. And
Did it make a determination when it decided to give the jury instructions over the objections of defense counsel?
Once again, Your Honor, I would go back to that argument and discussion is about the definition of putative father, and that their argument is really that putative father, putative parent should not be in the statute, not that the definition so much is in error. It's all about that it's overbroad. Yes, it is a potential parent, it is a potential or a possible parent, and the allegation has been made, but it hasn't been proven. If it has been proven, then they are no longer a putative. They are either an established or a natural parent, or if there's family or household member established.
Doesn't it require the birth of a child to be a parent?
I'm sorry?
Doesn't it require the birth of a child to be a parent?
To be a putative parent, the statutory definition that was referenced by the court and in the adoption statutes references conception and their marital status at the time of conception. And so I don't believe that that is established in Ohio law, and as counsel is saying, there isn't a court that has definitively addressed that issue, and I don't believe that it's necessary in this case because, once again, as I said, this issue wasn't raised below. This issue has been waived on appeal, and that is our position that unless the trial court makes a determination on that specific issue, and I understand your concern that by upholding the guilty plea or by denying the Rule 29 motion, the court is saying that the statute applies in this case.
No, what I'm saying is that it was raised on Rule 29, which is a sufficiency, unless you can cite me to case law that then waives a specific argument of sufficiency while the sufficiency was raised on Rule 29. And even so, there was an objection from trial counsel with regard to the usage. In fact, during closing, trial counsel argued with regard to punitive parent and was stopped, was brought into chambers, seemed to have been admonished by the judge, and the judge made determination that it applied and actually said that it applied and then gave the instructions for punitive parent.
I guess where I would go back is that in terms of the Rule 29 and the sufficiency, the argument was never raised in either of the Rule 29 motions that a unborn child does not qualify under the statute. That definitively was not raised in either of the Rule 29 motions. And because that was not raised, you cannot now challenge the sufficiency of the evidence to establish that the statute, that statutory portion on appeal now. The discussion about whether or not, and the reference.
See, what's interesting about your argument is also this: if someone doesn't raise a Rule 29 sufficiency, but then raises it, don't we review it on plain error because it is sufficiency and we're talking about somebody's liberty interest?
And I want to make sure that I'm understanding the question. If they don't make a Rule 29 motion at all, then it would be a much higher, arguably I would say that it has been waived. They are conceding that the evidence that was presented was sufficient. So it would be in the context of like an ineffective assistance of counsel for not raising it, or some sort of multiple layers removed from the standard here. But the case law is clear before this court and the Ohio Supreme Court that if a specific issue is litigated, or specific issues are attacked in a Rule 29 motion, those issues not raised are conceded, and they are waived for further review in terms of the sufficiency of the evidence. I'd like to, if I can, and I don't want to cut off any of the questions, but I'd like to come back to, and Judge Myers, I believe it was your question as to whether or not it would make domestic violence inapplicable to pregnant girlfriends, because if they're married, there's a presumption that if they're, if they're married, then they're married, or if it's, cases like that. And I think absolutely that's what it does, is it turns cases like this into a simple assault where the entire reason why he's assaulting her in terms of the evidence that was produced at trial was in reaction to her claiming to be pregnant and to showing the pregnancy test. And I think the statute clearly intended to protect pregnant women regardless of their status in this case.
Aren't there parts of the legislature, of the legislations where the legislature actually specifically discusses unborn child?
There are other
provisions.
Other provisions not raised and discussed here, so I don't feel completely prepared to address
Right.
that.
So how would you address the argument that if the legislature so intended with this statutory provision, they would have also provided such?
I would go back to the one, that it's inclusion of putative parent, in this case putative father, is a clear indication of that and that intention, where there's the allegation of that. In terms of putative father, I'm unaware of anywhere in Chapter 29 where there is discussion about, that specific issue, where in terms of a definition of putative father, in terms of Chapter 29. So I think that the court, because putative, as we're arguing here, is not a commonly used term and a commonly understood term, it was necessary for the court to instruct on that term. And the court had to find a definition from somewhere in order to do it.
Can I interrupt you and ask
Yes,
you a
ma'am.
question? What, if any, relevance does the general definition provided in 2929 for person that defines person as a viable fetus? Does that have any guidance for this court on child?
Your Honor, I'm going to go back to that wasn't specifically raised, so I'm not prepared to present a case law in interpretation on that specific subsection of the statute. That wasn't raised in the briefing or below.
Well, the reason I raise that is if we're struggling with whether this particular statute, and that's all we're looking at, this particular statute, whether child includes an unborn child, I guess I'm just wondering, do we look beyond that to see what the legislature has said in determining what a person is?
I would say in response that the proper way to challenge that would have been to have raised a constitutional challenge, that the statute is overbroad in its inclusion of putative and the court's interpretation of putative as including their specific issue, and that constitutional issue would have needed to have been raised in the trial court in order for it not to have been waived before this court. And once again, because that issue was not raised below, it can't be raised for the first time here on appeal.
And you have about 1 minute left. We've taken a lot of your time, I know.
Let me try and see if there was a highlight that I wanted to get to. I think that there's no question that that an assault occurred here today, and that the issue of the status as a putative father, the objection to that both below and here is about the statute's inclusion of that, not the trial court's instruction on that. It's not that instruction, the definition being given is overly broad and includes an allegation of parenthood. Well, yeah, that's what putative means, and the court had to give an instruction. So I don't believe that it was error for the court to give that instruction. Beyond that, the issue as to the status of the fetuses, whether or not it is a child or not, I don't believe was appropriately preserved for this issue. It is more proper for a constitutional challenge to the domestic violence statute in an as-applied challenge. And since that constitutional issue was not raised below, I don't believe that it can be raised for the first time here on appeal. And I think that Ohio law supports that all constitutional challenges not raised below, just as all of the sufficiency issues not raised below, cannot be litigated for the first time on appeal.
You are at your time. Judge McClure,
I actually have a question, getting back to the jury instruction on putative father. Once the trial court read that instruction to the jury, did defense counsel object on the record again to that? And if you don't know, I can look. But did defense counsel object to that instruction being read to the jury to preserve it?
I believe that all of the objections, and I'm sure Ms. Nelson will correct me if I'm wrong, I believe that all of the objections happened prior to the instructions and that there was not an objection when the actual instruction was given at that time.
All right, thank you. Ms. Nelson, you have 7 minutes remaining.
So I promised I would address the closing argument question, and my notes pretty much comport with what you alluded to earlier, that trial counsel did try and challenge during closing arguments that the putative father wasn't applicable to this case. They were brought back into chambers and counsel was admonished. So to the extent that trial counsel tried to persuade the jury that that element was not met in this case because it didn't meet the standard that they were going to be instructed on, trial court even disallowed that from going forward. So with that in mind, I think there's a repeated attempt in this case for trial counsel to convey not only to the court but also to the jury that putative father doesn't apply here when there's no child in the mix. That objection is found in the transcripts. I know that the page numbers are a little off in this case, but where closing arguments come into play, or the jury instruction, the page range is 62 to 65, and that it's preserved. This issue is squarely preserved for the trial court in terms of how do we apply putative father under the facts of this case. And we can't just look at that term in isolation. We have to read it in the context of the entire subsection F1B. So to say that we didn't specifically challenge what the term child is would just read that part of the statute out of the analysis, and we can't do that. We have to read all of these terms in conjunction with one another.
How would you respond to the state's argument that your argument, in effect, is a challenge on statutory language, and that it is a as-applied constitutional challenge?
I don't think we're there yet because there's no case law that has defined child in this context to mean a child that is born. So we're not at a constitutional question yet. We're really just asking this court to interpret what the statute means by its plain language in a lot of ways, but also by drawing on the other statutory terms in the criminal code and the adoption code. So we haven't really broached the concept of a constitutional as-applied challenge yet. I mean, effectively, that's what the result would be, but first we have to start with, well, what do these terms mean? And that's a straight de novo statutory interpretation question that I've personally never raised also in conjunction with a constitutional as-applied challenge. I mean, I've raised statutory interpretations questions before this court, in front of this court before, without the accompanying constitutional issues. So perhaps it's a learning point for me in my practice, but I think that this court can squarely answer the statutory interpretation question without the presence of a constitutional claim.
Thank you.
Ms. Nelson, let me ask you, and I know the thrust of your argument, but it's my understanding that the prosecuting witness alleged and the father, just say putative father, acknowledged that she was pregnant with his child. Wasn't that? I thought that was established through the testimony of the police officer when he went to the scene, and he subsequently admitted that she was in fact pregnant and it was in fact his child. Was that established at the trial?
I don't recall that being established to the officer, but I do recall that the prosecuting witness testified that once the police were present, that Mr. Brown had made a comment about, this is our child, you make me so angry. But I think the context there is that he was trying to encourage her to not speak to the police. So going from a heated discussion, which I push back on the state's argument that this altercation came from the pregnancy announcement. No, this started because she confronted him about cheating. And it wasn't until the mom intervened that she made the first reference about being pregnant. At least that's how she testifies to this series of events in the transcripts. With respect to the court's concern, I guess, about this precluding any sort of domestic violence claim against pregnant girlfriends, we also have to consider situations like one-night stands, right? So yes, there could be situations where couples are in a certain relationship that may result in the conception of a child or a fetus, but we also have other types of situations where there's not really a relationship ongoing, where there's a one-off situation that a child is actually or a fetus is actually conceived. So really, what we're looking at is, does the domestic violence statute cover this type of relationship from a wider lens? Because it could, in fact, cover more types of situations that don't exactly meet the traditional domestic violence family protection situation that DV is aimed at. That's why we're trying to differentiate between situations that may be more aligned with the facts of assault, which also contemplates harm to a person's unborn. That language is in the assault statute. So again, I think the language in the criminal code, the adoption statute, the domestic violence statute, all sort of lend itself to suggest that the natural parent of any child means the natural parent of a child, a person that is born. And when we're dealing with pregnancy without other factors, we need to maybe align that more with the assault statute.
And I agree with you. The statute doesn't try to define relationships because, in other words, if somebody had a 10-year ongoing, intimate, and very close relationship with their partner, but weren't living together and didn't meet any of the other definitions and there was an assault, that wouldn't be domestic violence under this particular statute. Is that right?
Yes. Yes.
So we don't look at it's not a test really of the relationship between the people. It's, do you meet the statutory definition, living together as a spouse, having a child together, debatable unborn or born, etc.
I agree with that, right? There needs to be, it has to fit within the confines of the statute, and there's plenty of case law delving into the F1A subsections, but not really the F1B. Again, we're just asking this court to hold that child has a particular meaning that is necessary to define before we even get to the putative father application in this case. Because their child was not born, Mr. Brown does not fit under that subsection, and this conviction should be reversed, at least remanded for a new trial to apply the terms as we're proposing to this court, or based on the sufficiency of the evidence, because family household member was not met, and in that situation, we would have a full reversal and discharge.
All right, and you are about at your time.
Thank you.
All right. Thank you both for your arguments this morning. We will take this case under submission and give you a timely written decision. Thank you. The next case on our docket this morning is it Kaiser or Kaiser?
Kaiser.
Kaiser versus Goff. Mr. Maislin is here on behalf of appellant. Ms. Keaton is here on behalf of appellee. Mr. Maislin, you will have 15 minutes to argue this morning. Would you like to reserve any time?
5 minutes.
All right, and I will keep your time. Whenever you're ready, you may step to the podium and you may begin.
Thank you for having us. So I represent Ms. Kaiser. She was involved in a really bad accident. She was a passenger in her own vehicle, and because of that, she wasn't afforded any of the coverages that she purchased through her own insurance. And this, as far as I know, in Ohio, this is a case of first impression. This is not the interfamilial exclusion that we're dealing with. It's more of this, it's like a passenger seat defense. And before I get into really the merits, I just want to point out, I don't know anyone, when I talk about this case, that would have any idea that they wouldn't be covered if they were in the passenger seat of their own car should they turn over the keys, which is part of the impetus of why I'm appealing this case, is because it's terrible. If you are if you're drunk or you're injured or you need to go to the hospital or you're tired and you turn over the keys to a friend, a non-family member, and they're driving and they crash, your insurance coverage will not cover you, at least under this policy. And there's really 5 reasons that, well, let me back up. Just because the policy is written a certain way, that's not the end of the equation. That's not where we stop, particularly in a contract of adhesion like this one. And that's where I'm going to start, is this is definitely a contract of adhesion. And because of that, there's also certain protections for the purchaser or the person who did not have any say in the contract terms. And in any insurance policy, in fact, I just bought one the other day, you pay your premium, you tell them what the limits you want, you tell them if you want full coverage, partial coverage, And then you don't negotiate any of those terms as the purchaser of insurance. They send you a policy and it sticks. It's a contract of adhesion.
Can I ask you a question about that? Putting aside that I realize the average person may not even understand every single provision in the long contract, but isn't the right of the person buying the insurance to go elsewhere if they don't like the terms of the policy? And does that take it out of being a contract of adhesion? Because you have a choice.
Right, and the answer is no. That doesn't change the fact that it's a contract of adhesion. A contract of adhesion is one where one party has no negotiating power. So it's not a statute where they're subjected to it. It's a contract where the terms are what they are. It's a take it or leave it. So sure, then they can say, well, I don't like this policy, and then they don't have to have it. But that doesn't change it from a contract of adhesion. That just means they don't want that contract. So then they go to the next policy, and they pay the money, and the terms come in. Again, there's zero negotiation with that. The policy comes in. They can get out. Now, remember, they're already contracted at that point. They've paid, they received the policy. They're in a contract. Can they then get out of the contract? Sure. They can get out of it, but it's still a contract of adhesion. Does that make sense?
Yes, thank you.
Yeah. So when there's no negotiation, that makes it a contract of adhesion. It doesn't mean that you're stuck with it. You can still get out of the contract, but it's still sticky terms. You're still stuck with the terms that they give you.
You know, Mr. Mason, wouldn't all insurance contracts be contracts of adhesion then?
Yes.
Okay, so what does one do?
Well, one does what we're doing now. And
Well,
when
well,
you have terms.
Well, let me ask you this, could one read the contract and say, well, I don't like this Safeco contract, I'm going to go to Allstate or Cincinnati Insurance or any other insurance company?
But they're all contracts of adhesion. So it's different. If I, it's one thing if you and I want
I
to.
agree with what you've said.
Okay.
All right, but isn't there an obligation on the part of the person purchasing this contract of adhesion to look elsewhere if they don't like it?
Well, I suppose if they don't like it, they can get out of the contract and then go purchase.
And I'll tell you why. Every time I tried a civil case involving an automobile accident, when I got home, I'd go pull out my insurance contract and see what it said. And maybe I'd make changes, maybe I wouldn't. But don't you think there's an obligation on the part of the purchaser to at least read the contract and understand it?
Yes,
Okay.
but that does not afford anyone negotiating ability. So like when I get my contract and I read it, and let's say I see this, let's say now I'm aware that this stuff is in here, right? It's sort of a convoluted non-definition exclusion. But let's say I figure this out because I'm me and I read this stuff. So I figure it out. Do I have any negotiating power? No, I have zero. I can't call up Safeco or Allstate or Erie and say, I don't like this term. Can you take this out? In fact, I'll pay a little more if you take it out. There's none of that.
Attorney Maislin, what in the record is there to support that this is a contract of adhesion?
Well, all insurance contracts are contracts of adhesion.
Well, you're arguing as if it is a matter of law, in which case then I would have asked, what's the authority? So if the,
Well, I mean.
and you can answer it either way. You can answer it on the record or you can answer it on authority.
No. I mean, I guess what I'm saying is, no one asked my client in a deposition, did you attempt to negotiate these terms? But I think it's common sense and it's within the routine practice of purchasing insurance. When you pay for insurance, it's bound before you even get the terms.
So are you asking us to take judicial review that judicial notice?
Yes, as far as it goes within the routine practice of insurance purchasing. There's no, at least in the 25 years that I've been doing this, and for every other attorney that I talk to and every other insurance person, you purchase insurance without even seeing the policy. When you receive the policy, it is what it is. You cannot go back and negotiate these terms. As far as the record goes, no, there's nothing in the record, but that is how it works. I mean, I don't know any other way that it does work.
Okay. So in effect, you're asking us to take judicial notice?
Yes, yes.
And Mr. Mason, if all insurance contracts are contracts of adhesion. So when something happens, we just don't apply. We just don't apply the terms of the contract.
Only in specific instances. Only in specific instances. So the answer is, generally, you do apply the terms if it makes sense and it's understandable. Then yes, you would, except where something is so unconscionable that and so unexpected that the regular person wouldn't understand that it would be in there. So I mean, imagine if there's a term in there, it's a contract of adhesion. Imagine it says, and now this is a silly example, but it says if you get into an accident, you lose your firstborn. Now, if that's in there, clearly a court's going to throw it out because that's so unconscionable and so ridiculous and so unexpected. And that's the argument that I'm making here. Obviously, it's not as bad as losing your firstborn, but nobody that purchases these policies is going to believe that they're going to be uninsured the moment they get into their passenger seat.
And you're not arguing that the contract says what it says. You're arguing that it violates public policy, that it's a contract of adhesion, that it's unconscionable, not that it doesn't say what it says.
Well, I think it is somewhat ambiguous, which is a little bit different argument. The answer is yes, that is the crux, the main crux of my argument. I mean, there is an exception. The first actually stated exclusion is we will not, here, wait, I can read it because it's, I mean, listen to the import of this first exclusion. We do not provide uninsured motorist coverage for bodily injury sustained by an insured while occupying or when struck by any motor vehicle owned by that insured, which is not insured for this coverage under the policy. So the import of that is that you can purchase it. So I am saying that there's an ambiguity in this policy. And I also point to that to show that even the people that wrote this policy didn't intend for someone who turns over their keys because they should to not be covered by their own policy. So, you know, what they're trying to do is escape from fraud, right? I mean, when you read this, that's what they're doing, is that you can't injure yourself and we won't cover you for that. But they back themselves into creating this passenger seat defense, which I'm saying is completely against public policy.
And you have 1 minute left if you want to reserve 5.
Okay. So it's a
I just
contract.
want to go back to contract of adhesion because you do argue in your brief, you do cite Patrick versus State Ohio Mutual Insurance for the proposition that there's already an appellate district that has determined that insurance contracts are contracts of adhesion. Am I understanding that part of your brief?
Yes, yes, Your Honor. Nothing in the first district here.
Understood.
So, you know, we just have to use our common sense. And what is insurance for? If you purchase full coverage insurance, you're not purchasing it for everyone else except for you if you're doing the right thing. And I think the best example, and then I'll leave it at this, is it just occurred to me a month ago or 2 months ago or whenever I was reading this brief that, you know, I have a nanny, takes care of my kids. The nanny uses my car because I have a nice car and my nanny doesn't have a nice car. And I'm doing it to protect my child. Now, if my nanny crashes, why is my child the only one who doesn't get covered by all that care? By the, you know, I have $100,000 in MedPay coverage, so that, and I have uninsured motorist coverage, and I have liability coverage. But why would the passenger seat ever apply to my child in my own car if I let my nanny drive them? Right? If the nanny crashes, they pay. My insurance will pay for everyone, except for my kid. And I think it's completely against public policy, and I think it's an unintended result.
Thank you.
Thanks.
Ms. Keaton, you have 15 minutes.
Good morning. It is my privilege to represent Safeco Insurance Company of Illinois before you today. Your Honors, this court should uphold the trial court's grant of summary judgment to Safeco on the Kaiser's uninsured motorist claim. There are no factual questions before the court. As Judge Myers pointed out, the argument is not what the policy says. It says what it says, and there's no question that Ms. Kaiser was a passenger in her own vehicle driven by her adult daughter, and at that point in time, her vehicle was not an uninsured motor vehicle, as that term is defined by the policy. The issue before the court is a purely legal one, whether the limitation on uninsured motorist coverage in Safeco's insurance contract is enforceable. And this is not a matter of first impression in Ohio. Nearly 30 judges from 9 of Ohio's 12 appellate districts, including this court in Kelly, have already considered the issue and found insurance contract language either similar to or the same as this contract language to be enforceable, unambiguous, and compliant with public policy. Again, this court need look no further than its own decision in Kelly versus auto owners for precedent in upholding the trial court's decision. In Kelly, the policy language, the underlying liability language, was identical to that found here, that liability coverage does not apply to bodily injury to you being the named insured. And in fact, the Ohio Supreme Court in Scheer versus Scheer recognized and suggested that its decision in Scheer may lead to this very type of exclusion.
Let me ask you this question. If the contract is clear and unambiguous, and the policyholder gets it when it comes in the mail, and she says, holy cow, that's not going to cover me if my adult daughter is driving, what's the remedy?
Her option, I think that the Ohio Supreme Court and the General Assembly would tell you that that would be governed by the fair markets. So that if she does not like the terms of that contract, they are not ambiguous, and so she can then seek a different contract of insurance with a different carrier. That would be the result. In Kelly, if I may, the uninsured motorist provision was slightly different from that found here, but the result was the same. And the result was that there was no liability coverage afforded the plaintiff in that case, and there was no uninsured motorist coverage afforded the plaintiff in that case. And that's the same scenario with which the Kaisers take umbrage. But Kelly and other courts considering this issue, and there are courts that consider identical language. So the 10th District in Smith versus Guide 1, the 8th District in, I'm sure that I will not pronounce it correctly, but it's Bousquet, maybe, Bousquet. I did not take French. They considered identical language and looked to the public policy set forth by the General Assembly in 3937.18 and found that, that uninsured motorist provisions may include terms and conditions precluding coverage so long as those circumstances are specified in the language. So looking to Kelly and Smith and Bousquet, this language in Safeco's policy has been found to be both unambiguous and adherent with public policy. Robson, the 5th District in Robson versus Allstate, noted that when a policy excludes liability coverage, it makes sense that it also would not then include uninsured motorist coverage for that same type of issue. And this court noted that an exclusion would be meaningless because family members could plot to recover uninsured motorist benefits in lieu of bodily injury coverage. And in fact, that is what the Kaisers have indicated, at least in their reply brief, that they are attempting, which is to, don't worry, I'm suing you on a technicality, but I'm suing you on this technicality to get to my insurance coverage. I do want to mention that there has been some mention, at least by Mr.
Wait a
Mason.
minute. I'm not sure I follow that. How's that a technicality? If somebody's injured by an uninsured motorist and the way to recover is by suing the driver of the car, I didn't understand that argument.
I'm not sure I understand their argument either, except to say that in the reply brief, the assurance from Mrs. Kaiser to her daughter was, I'm not really suing you, it's just a technicality to get to my insurance coverage.
Well, that's how it works always. You sue the driver. I mean, you're not saying there's something wrong with that.
No, I'm not saying that
Oh,
there's something
all right.
wrong with that, but I think that the goal is to try to avoid the terms of the contract.
Can I ask you a question that probably doesn't have anything to do with the legal interpretation of this, but what's the policy behind having that exclusion in these contracts?
I don't know that I can speak broadly because clearly many insurance carriers include this type of language in their contracts. But the idea is that the vehicle is insured. It is not an uninsured motor vehicle. So the idea for uninsured motorist coverage is if you get into an accident, if we are in an accident together, Your Honor, and I don't have any insurance and I am at fault, you can recover under your own insurance contract under the contract language. So I think that that's...
All right, thank you.
If I may briefly address the ambiguity arguments made by Mr. Maislin, I should mention that that was not argued before the trial court, and it was ambiguity law was generally argued by way of footnote in Ms. Kaiser's brief, but it was not actually argued until reply and then today. But again, various courts, including this court, have found similar language to not be ambiguous, but to be clear and conspicuous. Does the court have any other questions of me? I think I've covered my arguments, but want to make sure that I afford the opportunity to answer any questions that you may have.
I don't have any.
I don't think we have any more questions. Thank you.
Thank you.
Mr. Mason, you have 5 minutes remaining.
Well, first I want to point out, the only time that the courts in Ohio, as far as I know, have ever looked at language like this is for the interfamilial exclusion, which is why I spent so much time in my first brief addressing it and how it's really not a favored provision outside of Ohio. That said, that's not what we're addressing here, and that's not what we're questioning here. What we're questioning isn't the interfamilial exclusion, it's the passenger seat defense, which I think is much worse. And one of the things that defense counsel just mentioned was that these exclusions are okay as long as they're conspicuous. Well, this exclusion isn't conspicuous. It's like the addition and subtraction of a definition. It's the addition of an exclusion and an anti-definition that is in complete conflict with an actual the first stated exclusion, which I know sounds confusing when I say it out loud, which it is confusing when you read it in the policy. So it's not conspicuous. I don't know of any public policy in favor of excluding people when they're a passenger in their own car. I can think of 1,000 reasons why public policy demands that you are entitled to coverage when you're in your own car, particularly if you paid for it. So, I think the unintended exclusion here wasn't conspicuous. I think it was unintended. I think it's against public policy. I don't think it was conspicuous, and it's a result of a contract of adhesion where no one could get out of this even if they tried. With that, I'll rest unless you have questions.
Questions?
Nope.
Thank you.
Thank you.
Thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion. And that will conclude our oral arguments today for the First District Court of Appeals.
It just, it's taking, takes a long time to say it now. Okay. I just wanted you to, you can, or you can just come back and check on it. It takes like, it can take up to 20 minutes. Okay. So.
Do that work?
Yeah.
Okay.
No,
I'm just trying to think, like, did I do that?
it had been a while, but so we were both like trying to work back to things.
That's what I was thinking.
Something. I think, what we had decided before, I think they were like, 2 meetings, like 8:57, go ahead and just hit record. Okay. You can go ahead and start everything. The only thing I will say is, if people, today was really quiet, if there's a lot of talking going on before I got first, I just tell everyone, hey, we're gonna start the.
And I did ask, I did let them know that we watched it.
Yeah.
If they're like, okay, we'll play this one. Nobody wants to see anyone. But yeah, okay. Yeah,
So, you're good.
so I'll come back up.
Yeah.
And then I'll, once they